It's a little bit after 7 o'clock. We have a quorum. The full board is here. I'd like to call this meeting to order. If everybody who's talking in the audience would please sit down. Thank you. I'm going to read the public hearing notice. People should understand that this is a continued hearing, and this is for the deliberation by the board. We announced at the last board meeting that we were not going to accept any additional public comments or questions, except as the board determined that it wanted to request such information of certain individuals or groups. But anyhow, here is the public hearing notice. The active Board of Selectmen will hold a public hearing on November 29, 2017 at 7 p.m., continued from November 20, 2017, in the Francis Faulkner Hearing Room 204 at the Town Hall, 472 Main Street, Acton, related to a draft modified use and site plan special permit decision 11/20/2015-459, excuse me, pursuant to sections 10.3 special permit, 10.4 site plan, 3.4.7 other public use, and other provisions of the Acton zoning bylaw concerning Concord's proposed upgraded public water supply treatment facility and related infrastructure at 180 and 182 Skyline Drive, Acton, Mass. 01720 on Magog Pond. The hearing is being conducted in accordance with a remand order issued by the Land Court in Concord's pending appeal of the previously issued decision. The draft modified decision that will be the focus of the public hearing, as well as related materials, including materials previously submitted to the Board of Selectmen during its previously conducted public hearing on Concord's application, can be inspected at Town Hall during normal business hours. Many of the materials are also posted on the town's website. I think that the proposed discussion tonight is going to follow this order. First, special counsel is going to lay the legal groundwork for the Board of Selectmen's deliberation. The board will then discuss the proposed amended permit decision, basically to determine where members stand on each proposed change. After a complete review of the current draft, we can take up any proposed modifications that members might have. If a member wishes clarification from an individual or group, he or she must explain for what purpose, after which either I will determine the full board's inclination, or if it's obvious on its face, I will conclude that the request is for information that's really irrelevant to the issues that the board must decide based on what council has said at the beginning. If an individual or group responds to a board request, I will entertain on a very limited basis requests for a brief 2-minute follow-up comments by other individuals or groups that are offering a contrasting or differing perspective. And finally, just a reminder about the code of conduct. It applies as to any responses to board requests, including any follow-up comments. This is a hearing on a serious matter, so I would appreciate everybody's conducting himself with some decorum, or herself with decorum. Turn off your phone ringers, and please no applause or God forbid, booing. So thank you, council.
Thank you. I actually was intending just to provide some procedural context and framework here. We'll start with that, and if the board wants me to elaborate on any of the criteria or legal standards, I'm happy to do that as well. But so tonight we've got two components. We have a continued public hearing that's open, so that if during your deliberations you have questions, you can get answers to those, and then primarily those are the deliberations. My suggestion, as reflected in your comments, Janet, are that the board focus on the modified decision that was presented to the Land Court and remanded back and provided at the commencement of this hearing process. Each of the board members, you're going to have a decision to make as to whether or not to vote basically yes or no. So yes, you support the modifications, having determined that they still support the previous conclusions that the project complies with the applicable criteria, or no. So I want to be clear on that, because apparently I wasn't clear at the last hearing that you do have the option here of rejecting these modifications. A no vote, in order for these modifications to be approved by the board, we're going to need 4 yes votes out of the 5. If that doesn't happen, the result, if that doesn't happen, the board then has 2 options. You can either end the proceedings then, and what will happen is the original decision will remain intact, and everything will go back to the Land Court. The other alternative, if the presented modifications don't pass, is to continue your deliberations and discuss the possibility of, altering that language to see if there's some other version of that you want to vote on. Obviously, at that point, you're voting on something that Concord hasn't represented that it would necessarily accept, so it's a different posture. And then I have a couple procedural reminders. At the end of your votes, we're going to want to have a motion to close the hearing, just to terminate that part of it. We'll want to discuss the notice of decision, depending on what it is, and the format and the timing. And we want to remember that we were under a decision deadline, a deadline to finalize a written decision. So if there's reason to, pursue an agreement for additional time, we'd want to accomplish that tonight. Thank you.
Okay, thank you very much, Jeff. And with that, I think that we should just get into the draft modified decision. Everybody on the board should have a copy. And I would just say the first couple of pages are just probably not going to be controversial. If anybody has any concerns about it, please speak up on the board. Page 4 has just one word change. There's some word changes on page 5. Page 7 has an option to add information. Small changes there as well. And an additional reference on page 8. Page 9, really no changes. Page 10 is where we have an additional bit of language basically pertaining to the archaeological resources and referencing the Massachusetts Board and provisions for exploration by those folks. If there are any concerns there, please speak up. Page 11, another few changes. I think there's a bracketed piece. There's some deletions there. Again, please speak up if you have any questions. Page 12, a couple of insertions. Page 13 is just in an option, just sort of a bracketed instruction for us to consider later. Page 14, again, other instructions. Page 15 is where we start to have a lot more changes, both additions and deletions. I don't know if you want to start talking about these things and the reasoning for, Katie, I know that you were particularly kind of well-informed about the concerns regarding archaeological resources. I don't know if you'd like to sort of share with the public what some of the reasoning was behind the changes that are in there, or not.
Sure, I mean, I think primarily, well, a lot of it was correctly spelling archaeology, but primarily a lot of it was about just codifying, and I think the important part, at least in my perspective, was codifying that that the town of Concord has to abide by the Mass Historical process for a Section 106 review, and that they have to complete their intensive survey, and then there was changes about how the procedure will work during the dewatering period, because I think that was the major thing. And so now it is that there would be monthly visits from the resident inspector, and that they will have trained somebody who is on site, because most of the time, we felt there didn't need to be somebody, a specific archaeologist on site at the time, but somebody that's been trained with visits from the resident inspector, and that if anything is observed, then it immediately kicks in state and federal practices that they have to go through anyway. So just recognizing that they have to undergo those, and I was comfortable with changing it to allow for just the the monthly visits as well as the training of the people who will be there, on the day-to-day basis. It's not a long period, hopefully, because that was the other part of this. I know we had a long conversation about the dewatering period, because there's balancing the period that this area will be dewatered and any environmental considerations of that, and then allowing for sort of these observations. And so that was the idea too, is that they felt, I think Cochrane was concerned with just sort of allowing anybody to go in, but so we just made sure that kind of what I thought were the main parties, including the state Massachusetts Historical Commission, the Board of Underwater Archaeological Resources, and the Mashpee Wampanoag tribe, who are the ones that were in this area. So that is sort of the major change there, and I was comfortable with those, and I think we had generally, in executive session, agreed that that was an okay change.
Okay, thank you. I think it was also important because the Conservation Commission had issued an order about the dewatering to sort of help balance the interests of the archaeological professionals and the interests of the Conservation Commission in kind of limiting the impact of the dewatering on sort of the resources that they're charged with protecting. So I think that this was the aim, was to accommodate a number of different interests in that area. I think that our original decision was a little bit more open-ended, and I think that this really pins down the standards a little bit more. The next issue, whoops, sorry,
Madam
go ahead.
Chair, I'm okay with this change. I did meet with Pine Hawk, the Friends of Pine Hawk, and the Littleton Conservation, or Littleton historical people. One thing that this reflects is the Historic Commission in Acton has their own protection under Section 106 of the National Historic Preservation Act. They contact the Mass Historic Commission directly. They can make suggestions about the project. My understanding is that Concord has to respond to those suggestions and provide alternatives if they don't agree with what the Historic Commission is recommending. So the Pine Hawk folks and the Littleton folks have already met with the Acton Historic Commission. I think Katie was there maybe at that meeting and discussed this issue, and will be communicating their concerns to the Mass Historical Commission. So I thought that gave our local historical commission an additional avenue for ensuring that protections were applied during the dewatering period. If any tribal artifacts are uncovered, the Wampanoag tribe has said in their submittal that they will send one of their members up to consult with Concord, and which Concord has to pay for, and come up with appropriate means of preserving that artifact or treating that artifact. These underwater artifacts, if they're uncovered under this guidance for discovery of unanticipated archaeological resources, they don't have to be dug out of the ground and somehow preserved. If it's a canoe or something like that, you document where it is, you take photographs of it, you document what it is, and you leave it undisturbed and covered up with water again. So that's my understanding of what the state policies required. I did have a couple of comments about things that we passed over, so I'd like to go back to that if that's okay.
Go ahead.
On page 14, we struck the statement 3.2.4, provide a statement detailing what Concord is committed to undertaking with respect to providing or facilitating a foot trail from the rear of the lots to the Breezy Point subdivision to the Naghog Hill Conservation Land. We have language further on which we'll discuss about dealing with the trail issue, but it is clear that we do not have the authority to require Concord to allow people to pass over their land. Cases have struck down decisions which have required easements for the public to pass across people's property. That is beyond our authority. So that was one of the reasons why we dealt with this in a little different way than we did in the original decision. And further down under enforcement, we struck the very strong language that we had that said we could shut down the site if we found any violations of the conditions in this permit. That is also not consistent with the way it works legally. If there are any violations of the conditions in this permit, the remedy for the town is to go to court and seek an order enforcing the conditions. And I'm comfortable with the language that says the town has the ability to enforce compliance with the site plan permit using any and all powers available to it under the law. So that's the thinking in changing that language.
Thank you, Peter, for filling in the gap. Joan or Ching-Sung, did you have anything that I skipped over that you wanted to comment about?
Many of my comments relate more generally to the decision as a whole and sort of what we are looking at. And so I guess...
Why don't you hold that until after we...
I will hold that until after the discussions is of to the specific language in question.
Joan, anything? Okay, I understand.
I want to add one thing, just when Peter was clarifying with the 106, because I think there's been some question about it, and I think people have to recognize it's sort of a timing thing, that 106 doesn't come into effect and it won't go to the Mass Historical Commission until there's an actual project and a decision for, that then there will be a project for the Mass Historical Commission, the Acton Historical Commission to review. So as Peter mentioned, they've been, and their liaison, we've talked to them about this. The Friends of the Pine Hawk and Littleton Historical Commission have talked to them as well. They're aware of the concerns and the issues, and essentially are in a holding pattern until there is this formal process that kicks in. And again, the main point here was to really emphasize that language that they have to follow the 106 process. So we just, they have to anyways, but putting it in there, I think, just, is a reminder to everybody. And Acton Historical Commission is aware of it and will be prepared to review and comment on the project when it is at that point.
Okay, anything further on anything up to and through archaeological resources? All right, the next section is fence installation. The principal change is that we deleted the reference to the potential for the applicant to agree to a shorter fence. A lot of the rationale behind this is that really the fencing, addressing the fencing was really not part of our proper purview, although we have gotten some compromise from the town of Concord, and that compromise, it remains in place. And then we also modified the proposed reporting to just 3 years after the fence is in place, and then inspection for as long as the fence is in place in the vicinity. Any other comments from the board about that?
Why 3 years?
That was, I think it was just that it was a reasonable length of time, but without being onerous. I honestly don't remember the precise.
I think it was just a balance of, it was 3 years for the actual annual report about the maintenance, but then we have in there for as long as it's in place that our Land Stewardship Committee and Natural Resources Department can go inspect it. And the idea was that if they have, that it would sort of, after 3 years, the maintenance work will, they would have it under kind of control and to everybody's agreement by then. And so they don't need to keep annually reporting on what will presumably be the same maintenance plan, but we can still continue to inspect it to make sure they're following that maintenance plan.
Any other comments about the fencing provision? Chemical deliveries and residuals removal, this entailed a fair amount of discussion because I think that board members were concerned about the impact on Acorn Park of chemical truck deliveries and trying to manage that. And so we have added the provision that Concord must inform the vendors of the restrictions that we're imposing on sort of the delivery hours and also the routes. But the effort is to try to control the drivers who are going to be making these deliveries and going through the neighborhood. And I guess that there's also, okay, and we delivered a provision. I think that was really to try to limit sort of efforts by us to add enforcement authority that maybe wasn't appropriate in this particular context. So, but we did stick to our proposed restrictions on delivery in an effort to control the impact on the Acorn Park neighborhood. Other comments? Okay, next section, we deleted, this is a big change, obviously. The monitoring program is completely deleted, and really, in a nutshell, a lot of this has to do with the fact that monitoring has to do with the impact downstream of withdrawals, and to the extent that monitoring downstream might lead to assumptions that we could try to regulate what was happening upstream with regard to the withdrawals. Withdrawals are really regulated by the state, pursuant to state law, and certainly with regard to the registered rights that Concord has, even at the state level, the ability to regulate short of legislation or actually regulation is very, very limited. So we just, after a fair amount of discussion, because we were aware that we had committed through a non-binding resolution to, doing some monitoring, we agreed to take this out. One of the other issues relating to monitoring is that it's water flow, water resources are not really sort of a simple matter to monitor, and I think the water district folks let us know that, the question is, where do you start and where do you stop, and what does it all mean when you have all this data? You can't assume that something downstream is attributable only to what's happening at Nagog Pond. Anyhow, there was a lot more discussion involved in this, but this is really a lot of the reason that we took it out. I think that probably at some point some sort of monitoring would be advisable, but it's not going to be part of this decision because we kind of agreed that it was beyond the realm of this decision to make, which is it's a zoning bylaw decision. Any other comments? Peter?
Well, I was part of the discussions that led to this modified decision, as we all were in executive session, but we held the meetings with Concord that led up to this, so I am also comfortable with this deletion. As you pointed out, Madam Chair, it's very clear under the Fairhaven case that the Water Management Act supersedes the authority of local zoning boards to regulate rates of water withdrawals, which this was intended to get at. But even beyond that, we've had a lot of conflicting testimony in this hearing process from various experts about the effects of water withdrawals on Concord's wells. That was one of the main concerns of a lot of the residents who came before us. I'm not a scientist. I tend to put my base my conclusion on the statements and opinions of the water district. We elect the commissioners to lead the district. They hire experts and environmental experts and water experts to ensure that Acton has a adequate and safe supply of potable water. They do the long-term water study to determine what our future needs might be. They have said there is no connection between the water levels in Nagog Pond and the ground wells at Conant 1 and Conant 2. So even if we had the authority to regulate water withdrawals from NAGOG based on our concern that it might affect the underground wells of Acton's water source. My conclusion is that there is no connection and it won't affect those underground water sources based on the expert opinions of the water district folks.
Thank you, Peter. Anybody else?
I'd like to raise the point that while a monitoring program designed to examine the impact of the withdrawals at NAGOG downstream of the downstream effects of Kona 1 and Kona 2 seems from the water district's testimony as well as other things to be not prudent and unnecessary both. I do think that to some degree instilling some protection for NAGOG Brook, which I don't think it's clear that the facility will not impact NAGOG Brook. I think that, and maybe it's not a monitoring program, I don't know what the right thing to do is, but having some protection for NAGOG Brook, I think, is something that we should think about.
Anybody else? Jim? Okay. The next paragraph is, it's now renumbered 3.3.7, Protection of Environment. It's retitled Protection of Environment and Natural Resources. This was really an affirmation by the applicant. Originally, it was to manage its withdrawals from NAGOG Pond in a manner that appropriately preserves and protects the water. And we just modified to say that the applicant would agree to act in compliance with any applicable laws and regulations regarding the protection of the environment, which is actually what it's appropriate because that's what the applicant is required to do. I think that protect sort of is a nebulous term and subject to interpretation. And so I think that it's a little more straightforward and sort of objective to say comply with the applicable laws, because that is what in fact we're expecting the applicant to do. And we added a reference to the Mass Water Management Act and other applicable state and federal laws and regulations, the Mass Water Management Act being the law pursuant that really is responsible for regulating water withdrawals at NAGOG Pond under state law. Any other comments? Peter?
Yeah, I just want to follow up on Chin Sung's comment about NAGOG Brook particularly. One of the things I've learned through this whole process, which at least in my view, seems to be the disjointed and haphazard statutes governing water withdrawals. If you pulled a certain amount of water out of the ponds within, in the mid-'80s, you were registered to continue pulling that amount of water. This is not just Acton, this is across the state. And it not necessarily, in my understanding, connected to the availability of water. It just was how much you were pulling at that particular time. It seems to have been tightened up more with the permit process. But as Senator Eldridge pointed out, these statutes were passed in the 1980s, and what year are we in now? 1980s, and they need to be updated. The brook is, it is a cold water fishery resource. I've been reminded that when we issued the permits from the CONSCOM for the original 18-hole golf course so many years ago, we had a 200-page study done on NAGOG Brook because it was a huge issue about how the golf course could develop near the brook. That study concluded that NAGOG Brook is actually an intermittent brook up by the pond, near the pond. It does have a bordering vegetated wetland, so the golf course was required to meet the setbacks under the Acton local bylaw, and that bordering vegetated wetland does protect the brook to some extent. Concord has the state has a generic environmental impact report, kind of a model plan for dewatering that Concord has agreed to follow. The Department of Fish and Wildlife will meet with Concord before the dewatering starts and go over the plan, but they will, continue to allow water to flow from the pond into the brook during the dewatering process at a certain rate that's specified in that environmental impact plan. And they've committed to meet all those requirements to protect the brook during the dewatering process. As far as operations goes, their stormwater protection plan meets also the requirements of the Division of Fish and Wildlife's plan. They don't like detention ponds because the water heats up and can seep into cold water brooks. So Concord, as I understand their stormwater plan, is all underground disposal of storm runoff, treated to an extent and infiltrated through underground soils before it reaches the brook, which is what I understand the Fish and Wildlife thinks is the best management practice. To the extent that operations and a higher drawdown of the pond water during operations after the new plant is built might impact the amount of flow that goes over the spillway. I don't see anything in Acton's or Concord's plans that talk about that, but I also don't see any state regulations or control over operations after the plant is built and its impact on the brook. Again, it's an intermittent brook up by the pond certain times of the year. Concord has agreed to do the dewatering during the lowest level of the pond in late fall. But at some point, I agree with Chin Sung, there might be something we could add to this to kind of ensure that the brook that Concord uses best management practices to protect the brook after the operation is underway. I don't know what those are. At some point, we might ask ORS if they have any suggestions, but that's my feeling on the brook situation.
Anybody else? All right, we're now up to 3.3.8, water supply coordination and planning. This provision really, the original provision provided for regional good faith discussion among Acton, Concord, I think also Littleton, about water supply needs, and in particular addressed the water supply, which has been ongoing by Concord for some time along Great Road, a section of Great Road between the Concord border and basically where the pump house is for Concord. This is not an obligation etched in stone or pursuant to any written agreement, and I think that Concord is prepared to engage in discussions with Acton about the water supply in this stretch of Great Road. I know that the Acton Water District also has the potential for connections in that area, but it obviously requires some coordination between the two water districts, and really this condition about continuing to provide water supply on Route 2A, including new water demands, was really beyond the scope of our authority under what is a zoning bylaw decision. So we stripped out a lot of this, but we are still committed in this provision to engaging in good faith discussions about general water supply issues. We have learned that the Acton Water District and their counterparts in Concord regularly communicate, as do a lot of the public water supply professionals, about common issues that arise in all the different communities. So it's not as if this is going to be a real stretch or something that the water supply professionals are not already doing. But in this case, it will involve more of probably the elected boards just being informed about what is going on. And but the provision gets deleted, it goes into, and then there's the reference to trails, which is actually the next paragraph. It starts in the middle of the discussion about Great Road water supply and sort of regional coordination. So, Katie.
Yeah, I just want to note that, again, I think we should realize that this process and this permit, zoning permits are not the end of all of this. It's not that whatever is included in here or not included in here is the end of the discussions that are going to be continuing to happen, or that it means that we're no longer going to be responsive, to the citizens' petitions. It doesn't mean that Acton can't and still won't and shouldn't, try to pursue our rights to Nagog Pond through the legislative procedures and to address, issues or concerns that we have about water withdrawals and the Water Management Act and other things at the state levels. But again, I think, as Janet mentioned, it's just an acknowledgement of what we felt was allowable and reasonable and under the purview of a zoning decision, and what fit under this versus what is not and what we don't think would stand up in a court of law as something that is a reasonable condition for a site plan or special use permit. And so again, this acknowledges that, while taking out some of the conditions around the, specificity of the regional discussions and about exactly who would be involved in 5-year progress reports and those things. It just, we felt that those weren't really things that would stand up or that were appropriate to this decision, but they're not things that shouldn't happen or that we won't continue to pursue. And if Littleton wants to talk to the Acton Water District in Concord, I think that's great, and we would support that, and we can encourage that, and we can be involved in that. But it's not, we didn't think that bringing in Littleton into this made a whole lot of sense going forward. So I just want to, kind of clarify that and note that this doesn't mean that we don't have concerns or that, we're not going to address them in other avenues, but that we're dealing with a specific avenue here, and that's what we have to focus on tonight.
Peter?
The reason that Concord supplies water along 2A is because the Acton Water District doesn't have a main that runs along 2A. Their main stops about the pump station that Concord has near where the bridge goes across with the new rail trail. So Concord had a concern because we have developed an East Acton Village District zoning plan, overlay plan, I think, that anticipates more intensive development in East Acton. And we had not provided any of that information to Concord about what that would mean in terms of increased water connections as development gets built out in the future. During this process, we had our planning department do an analysis of that. It turned out not to be a huge increase. We gave that information to Concord, and Concord has agreed to enter into these discussions with the Water District. It's an important issue to all the citizens of Acton, because if Acton has to build a water main along Route 2A to service future development or even current development, if Concord were to for some reason stop providing that water, I think I remember a figure of $3 million a mile that would be assessed to the Water District members to pay for it. So the hope is that with that exchange of information and good faith discussions going forward, that we can work out a deal where the water is similar to the deal that the Water District worked out with Boxborough, where we can get Concord to continue to provide the water that it does now and provide new connections as development continues along 2A.
I would add, I recall that Acton Water District actually is, Concord and Acton have water supply options that are in closer proximity in Great Road. I know that I think that there was an arrangement to provide water to there's a proposed development, 7 Great Road, whatever, it's a bunch of antique houses, and I think there's a proposal to have a line running from the Water District's main, which I think runs up Pope Road, and go under, I guess, the nursing home, something like that. But anyhow, if anybody on the board wants clarification of that, I know that Matt Mostoller from the Water District is here, but I do recall it's not really important for our purposes, but it may be if we want to make sure that we have the information correct about what the service situation is on the Great Road in that area. But otherwise, I'm not, going to inclined to ask the question if nobody else wants. Any other comments? All right. The next paragraph is 3.3.9. It is it's about the trails, and originally this was a much longer provision, really requiring that discussions about access for Breezy Point, Quail Ridge, and Acorn Park. It has been simplified somewhat. It now provides that within 45 days of this decision becoming final, the applicant shall engage in active and good faith discussions with the Acton Natural Resources Department and the Acton Land Stewardship Committee. I've got to read through it. Yeah, I should have taken the unredlined version to read. Regarding, 1, the use of designated trails by pedestrians on Concord's water supply land and Acton's adjacent conservation land, and 2, possibilities for connectivity from the Breezy Point subdivision to Acton's Nagog Hill conservation land parcel. It is understood that during and after such good faith discussions, Concord may, in the exercise of its discretion to assure a safe and clean public water supply, impose restrictions on public access to its land at Nagog Pond, including but not limited to prohibiting such public access. This provision, it does reflect what had some incidents that occurred earlier this year at Nagog Pond, which seemed to be breaches of security. They're a matter of Acton Police Department record, and so aside from the fact that generally, probably since 9/11, security concerns are heightened generally around public water supplies, this was another reason for Concord's, it sort of explained why Concord has become quite concerned about assuring security of the facility. It is a place where people, because has been no fence, there have been no trespassing signs, people do tend to wander over there, either knowingly or unknowingly, and the dam is an especially attractive location, and it's probably one of the most sort of important areas to protect from people who might want to do something illicit. I think that we did preserve the provision about trying to work with Breezy Point residents, because they did bring that up quite early. Some of the other issues I think came up later in our original discussion, but it was very important that the people involved in the discussion not simply be Concord representatives and the residents, but Acton's own volunteers who are very familiar with how to lay trails, where trails should go, all of that stuff. So that's why the reference to the Natural Resources Department and the Land Storage Committee, those stay in, just to provide a little more credibility for whatever the result may be. I think that they're Acton, but they're still arguably are impartial professionals, and in the event of a difference of opinion, I think that I would probably give more weight to where the Natural Resources Department and the Acton Land Stewardship Committee thought a trail should go. So, any comments? Katie?
Yeah, I mean, I just want to add, again, I think this was recognizing, as you mentioned earlier, that this is private land. And I also want to say, I hear the residents and the neighbors, and I sympathize and I understand the frustrations that, you've had access to this land in the past, and you've been able to, use the trails. And it's frustrating that now you might not be able to if Concord changes their mind on that. But it's also a recognition that that's their private land and they own it. And as Peter mentioned, we can't force people to allow others to access somebody else's private land. I can't decide if somebody wants to build something next to your house tomorrow that well, in doing that, I'm going to force you to allow everybody to now go through your backyard to get to where they want. And you wouldn't want that for the most part, except Franny, who did. And some people might, and that's great. And I think that's wonderful. And I think Concord is open to continuing to discuss access and allowing it. But there's just, you know, we have to recognize that it's not public land. It's owned by a public entity, but that doesn't make it public land. And so I think there's a difference there. So I want to say, you know, I hear you and I share your frustrations, but I'm also facing the reality that this is private land. And, you know, it would have been great if Concord had just accepted those provisions, but they didn't. And so we have to recognize that and deal with legal realities.
Anyone else? Peter?
No, I would just add that I have a lot of confidence in the National Natural Resources Department. If you don't know Tom Tidman, he is a sterling employee, our conservation agent and head of the Natural Resources Department. And the Land Stewardship Committee does great work in identifying open space parcels that the town should acquire. And this Land Stewardship Committee has open public meetings. They're a town committee. They meet regularly. Certainly could attend those meetings and bring maps and talk to them about what possibilities might be for trails, as well as with Tom Tidman. I'm sure he'd give time to residents who are concerned about this issue to look at the possibilities and come up with solutions. Well, one of the issues was, I think, getting across Nagog Brook, which, if I remember right, was a problem. So I would encourage residents to get in touch with those committees and the Natural Resources Department and bring your proposals to them as they meet with Concord.
Anybody else? All right, the next provision is 3.3.10. It's construction period. The discussion around this provision had to do with kind of trying to restrict the scope of this to damage, wear and tear that was reasonably attributable to Concord's construction vehicles and the like, because it'd be different if these roads were going to be roads that only Concord's vehicles were using, but they're obviously being used by a lot of other vehicles, and I think that it was reasonable for Concord to expect that its obligation under this provision would be limited to damage that was reasonably likely to have resulted from its vehicles, and which is why we added a video survey to just sort of document the start conditions, and then there's also a video, I think, provision at the end during the post-construction inspection, which they have to do a post-construction inspection and submit to the Acton DPW Director report and video survey documenting the general conditions of the subject public and private roadways. Comments, the board, anybody? No? Okay. Next provision is independent construction monitor. I think that that Concord might have preferred that we didn't have to keep this provision in, but this was a provision that our board really thought was important, and in the long run we thought that it would be helpful to Concord to have somebody who's on site who could not only kind of take some of the burden off of say, town staff members who might be getting calls, but also would alleviate some of the burden on Concord by having somebody on site who was aware of what was going on with regard to the construction and would be able to be in a better position to deal with complaints about noise or damage or whatever. We did impose sort of a limit on Concord's obligation for the costs is up to a maximum of $15,000 in the first 12-month construction period and $10,000 in each subsequent 12-month construction period, and with no carryover of the funding from one 12-month period to the other. But otherwise, the balance of this provision is largely the same as in the original decision. So, comments?
No, I would just say it's up to the acting zoning officer to come up with the scope of this. It was my understanding and anticipation that part of the scope would be meeting with the resident groups at Quail Ridge and Acorn Park, and setting up a communication between them, the construction manager, who can then pass along concerns, suggestions, questions to the developer.
Any other comments? Okay. The next provision that involves a change is minimize neighborhood impacts. Every reasonable attempt, this is the modified version, every reasonable attempt consistent with standard construction management practice shall be made to minimize any adverse construction conditions and impacts to neighboring and abutting properties, such as, but not limited to, dust, noise, etc. This is to make it a little more focused on what it is that you're trying to avoid impacts on. No comments, okay. And then we've added a paragraph 8, this is it's a subparagraph 8, referring to bald eagle habitat, and Concord is already in communication with Fish and Wildlife, the Federal Fish and Wildlife Department, and the counterpart for Massachusetts about the bald eagle's nest that is located on Nagog Pond, and about which we received abundant, very beautiful photographs of the eagles that were, I guess, there. But Concord has been working with the state and federal officials for some months, and is obligated under this new provision to take reasonable efforts to avoid disturbance of the nesting eagles, and to do whatever the state and federal officials might require in addition. So, comments, questions? But I would just like to say that is, I will give due credit to Ainsley Brennan, who was very dogged about keeping us apprised of the eagle's nest. And I also conferred with Tom Tidman, who is pretty savvy about eagle's nests and just wildlife in general. Any other comments? Okay, 3.3.11, post-construction noise monitoring. This is just a one-word change. It's just providing that the applicant shall conduct an acoustical study. Just change in verbiage. No change in 3.3.12. We deleted the provision for compliance with health director requirements. I think we decided it was maybe superfluous. I don't really remember the rationale for that. And then the next provision, new number 3.3.13, is water service lines. We've added a provision to this. The original provision was all water service lines that bring Acton Water District supplied water to the facility shall be installed in accordance with the specifications of the Acton Water Supply District, subject to Acton Water District's discretion and approval, and to the extent feasible, the water service for the facility may access the Acton Water District water main located on Skyline Drive. Other comments? No. Now we get into limitations, which is big paragraph 3.4. 3.4.1 is Acton's right to use Nagog Pond. This underwent a fair amount of sort of wordsmithing. Trying to see what it is that this. Essentially, this reaffirms that this decision does not alter, affect, limit, whatever Acton's legal authority to use Nagog Pond as a water supply in the future. But there are some word changes, deletions and additions. So, comments? And that is it. So I'd be interested in hearing what board members think about this draft decision as is. Katie, go ahead.
So first I want to just start by thanking all of you and everybody who's not here tonight, who's been involved and been really engaged in providing expertise and input throughout this entire process. I was noting to Janet at one point that when we first started this, I was the chair of the Board of Selectmen. Peter was the chair of the Board of Selectmen, and now we're on to Janet. So it's been quite a process, and all of you have been very involved from the beginning. And so I want to thank you for that, and to make sure you know that your thoughts and input haven't gone unheard, and that I think we've tried to incorporate a lot of what we've heard, and at least I know I've considered it very heavily. But again, for me, as I mentioned earlier, tonight this really comes down to me, the fact that this is a site plan special permit, and that it's really, as Jeff has said, a zoning decision. And so in thinking about that, you know, I've thought about it, and, you know, I find it hard to find that this permit would be injurious to the neighborhood when the use is essentially staying the same. The building's not going to be visible now that they've, you know, made changes. It's on the same footprint that it's currently on. The traffic impacts will honestly be minimal to the neighborhood after construction, and we've tried to put in place the conditions that are frankly a lot stricter than we have in most of our zoning decisions to protect the neighborhood during and after construction. And I think, you know, again, the main comments that we've heard, I think at the last hearing on this, on the modified decision on Monday night, I heard about 2 comments related to sort of neighborhood or zoning issues, and most of the comments were related to potential impacts on Acton's water. And that's been the big question, and I think a main concern, and it is a concern, and it's a concern of mine. It's understandable. These are issues that, you know, again, as Peter noted earlier, you know, he's not a scientist, I'm not, none of us on the board are, and so we've appreciated folks that are, but we've also heard different opinions about what impact Concord's use or increased use of Nagog Pond might have on Acton's water or water, you know, anywhere downstream. But frankly, I don't believe that we have the authority to determine Concord's water withdrawal. That's not what we are being asked to permit here, and it's not what this board has the authority to regulate. Senator Eldridge made comments at our last hearing a week ago Monday about the failures, essentially, of the Water Management Act, and about his efforts to try to change that at the state level, you know, and I think he expressed a lot of concern, and I share that, and frankly, it has been a failure of the legislature, not, you know, despite all of his and others' efforts. But I think that is the avenue through which we need to make changes, and so as I mentioned tonight, this permit and our decision is not the end of how I think the board or the town should be involved in this. So all of you, again, have been involved in this for over a year now and have been very enthusiastically involved and engaged. And what I would encourage you to do is to, you know, is to keep that activism and to direct it towards using all of this energy towards making a change to state laws around water regulation. It won't affect just Acton, but frankly all of the state, and I think that's a good thing and where it needs to happen. I think that the Board of Selectmen should be involved in that, and I'm going to encourage us probably, I would say maybe through our Water Resources Advisory Committee, or if another citizen committee forms, or if the board wants to form a specific committee to look at these issues, but to think about how we can best lobby the DEP and the state legislature, you know, you know, specifically, I know we've been told that Concord's water management authorization is up for renewal, and so, you know, let's be involved in commenting on that process, and I think that we should be, but those are the arenas in which I think that we have the authority to do that. I also think that we should continue to, and I think that we had agreed to and put it as one of our goals to still work on clarifying legislatively what our rights are to Nagog Pond and what the process would be to exercise those rights. You know, I think we understand that we do have a right to them, but what is that legislative process that we'd have to go through? Senator Eldridge was here. I think he would continue to be engaged with us on that, but it really needs to, you know, we need to lay that out, as the Acton Water District mentioned on at our last hearing. They went through a similar process with Boxborough, because Acton had rights to water in Boxborough. And I worked for one of our state representatives at the time who represented both Acton and Boxborough, and I remember those discussions. And it took years to get that resolved. And I think that this process likely will take years to get resolved, but we have to start doing it. And so I would encourage us and would like to say that as a selectman, I will commit to continuing to do that. Again, we also will still continue to negotiate with Concord on the issues related to water on 2A, to the fencing and trail access issues, to working with the water district on regional agreements and data sharing and some of the other issues that we've had come up. But again, for me, I felt like those were largely outside of the purview of this zoning decision. It doesn't mean that they're not important issues. It just means I don't think that this is the correct avenue or what would be withheld in a court of law or held up in a court of law if we try to put these as conditions to a zoning permit. So in thinking about the main question, I do disagree that we would prevail in a denial of this permit. Sometimes in the past I've said in executive sessions and related to other issues that I think it is worthwhile to chase windmills, to make a statement or for other reasons, even if I think we won't prevail. But in this instance, I think it's better to retain some control over our permit and to have the conditions that, have been agreed to stay in there. We run the risk that if it gets appealed and brought to court, that some of the things that Concord would have agreed to get thrown out, and then we're in a worse place than we are today. I also think that it's better to maintain our relationship with our neighbor so that we can continue to have discussions on these important regional water issues, the trail access issues and other issues. And other issues, frankly, outside of water. I mean, they're our neighbor. We work with them on a lot of things. And I don't think that, it's worthwhile to damage those relationships. So with all of that in mind, I feel comfortable with what we've agreed to through the executive session discussions and the modifications that we've put to this decision. And so I'm comfortable voting for the modified decision.
Do you want me to go next? Do you want Peter to go next? Do you want Joan to go next?
I know that you're probably going to say that you want changes. So why don't I'd like to hear from Peter and Joan, and then we'll start. I assume that's what you want to do. You want changes or something? Because I want to hear about.
I can quickly summarize my position for you without going into detail, but I would like to sometime later make more detailed comments.
All right.
My overall position is that I believe that this decision hews much more closely to a good zoning decision than the previous one we issued. In terms of its contents, as far as in terms of its reach, not in terms of its contents. So therefore, in that sense, I support the changes to this decision and would vote to support them. However, I do think that this decision itself is a decision that I would vote against. And so therefore, I would like two votes. One, whether or not to adopt the decision, the modifications, which I would vote in favor of. And a second, whether or not to support the modified decision as a decision for this site plan special permit, which I will be voting against. If you would like me to elaborate as far as my logic, I'm happy to.
Let me, it's better for me if I restate what you just said so that I can sort of, okay, you want two votes, one on the proposed changes, and then a second vote on the whole decision with the proposed changes, which means three, you have additional changes that you would like to propose, right?
Not that Concord is likely to agree to. So no, I don't.
Okay. I really, I don't know the point of, asking for a vote on just the changes themselves. I think that the point is to support the decision with the changes, and so if you want to vote, we'll have a vote on the whole decision, but first, okay, I understand what you're saying, and if you want to elaborate later, you may do so, but first let me see what people's input is on the decision as it is without any changes. Peter, do you have anything to say? I know you had mentioned something that you were thinking about adding, but I honestly don't remember.
Well, I'd like to hear from the gentleman from Oars. He did have a recommendation that understanding that we can't control the withdrawal rates from the pond, I think he suggested there might be some monitoring that could be put in Nagog Brook to determine if there was an adverse effect on Nagog Brook from increased water withdrawals from the pond. Concord's response was, what do you do with information that you get? We clearly couldn't say stop drawing the amount of water you're registered to draw. But I think Green Acton might have pointed out that at least if the information is there, we can bring it to Concord's attention, and there might be some resolution to try to correct the problem. So I'm not sure what the monitoring was that you were talking about, if you have any further, more details on that. I know I've heard there's already a temperature gauge in there that I think probably was put there as part of the original golf course permit.
Peter, let me, before the way this works. Okay, but I want you to make sure that you understand that before you ask the person to come up, I want to see if the rest of the board wants to get clarification. Are you ready for me to ask the other? Sure. If the rest, what's the feeling of the rest of the board about getting clarification on that issue?
We're getting clarification on their recommendation for what monitoring in Nagog Brook might look like.
Right.
That's fine.
Okay. That's fine. That's fine. I would add that I think the Water District also said that, well, if you monitor Nagog Brook, what are you going to do with that information? But I don't know if you're talking about Professor Shanahan. Is that who you're talking about? I thought I saw him walk in. I don't know if he's.
Yeah, I think.
Okay. Professor Shanahan, if you'd like to go to the microphone and to the extent that you can address that issue, that'd be helpful.
Thank you for the promotion. I'm actually not a professor, so. I was a senior lecturer, but I'm retired from that.
Oh, you're Dr. Shanahan? I don't know.
That's it, yes.
I assume all PhDs are professor, but sorry.
The proposal that we had is really laid out in our letter. It's something that quite similar to what has already been done, in that a gauging station was established. And so a lot of the investment needed to create an operating gauging station has been done. And so a gauging station that monitored flow in Nagog Brook and temperature in Nagog Brook, I believe, could be done pretty efficiently and pretty inexpensively. How that and I think also the other thing that ought to be monitored is how much water is released over the dam. And that's a fairly straightforward measurement. I actually kind of expect they would be doing that anyway. I'm not 100% sure of that, and I'm sure they can clarify. What that information would then allow us to do, I think, is, first of all, understand what's happening to the brook. And while there would not necessarily have to be, or I wouldn't have a suggestion as to what would be, say, an immediate action or limits or so forth, but I think that body of information then could be used to make better decisions in the future, would likely be something that could be used in the Water Management Act process. And if there were adverse effects, those would become apparent and could be dealt with. The best case is there's no adverse effects. We learn a little bit more about Nagog Brook, and everybody goes home happy. But it is an important resource because it is a relatively rare cold water fisheries resource, and this would allow us to monitor it and see if it's being maintained.
Okay, thank you. Yeah, Peter, do you have a follow-up?
I just have a couple questions. Is it USGS who monitors the gauges there now? Who reads them?
It's actually not in place right now, I don't believe.
Oh.
I mean, I don't think it's actually being monitored.
Has the site now.
Sorry?
The Ridge site is, they stopped collecting data.
Yes.
Green Acton has a site there.
So Green Acton is continuing to maintain the gauge and collect information?
It's not the same site.
Okay. Okay.
If you're not able to answer it, just say you're not able to answer it. I mean, that's fine, Peter. I think that we're starting to get sort of crowdsourcing for the response, yes. And I don't want to get into that.
My understanding is that, it's not operational right now. USGS was consulted, I believe, in establishing the gauge, but they did not themselves maintain it, as far as I know.
Okay.
Okay, thank you.
Anything else, Peter? Okay. I'm going to ask a question of Concord. What is your response to the suggestion about monitoring Nagog Brook and also the issue of measuring or monitoring the amount of water released over the dam?
Thank you very much. Peter Durning from Mackey Shea for Concord. I want to acknowledge the time that you've all taken on this careful deliberation. I know last week I think I was pressing for folks to go on, but hearing how deliberative you have been, I appreciate your time and energy on this. I think as we have discussed previously, and I think as Katie just highlighted in her comments, and we've expressed consistently, there's a limit to what this board can do imposing controls on the withdrawals. And we certainly see the imposition of a requirement for down facility monitoring to eventually be a mechanism whereby folks would seek to curb or limit the withdrawal. And I believe Dr. Shanahan's comments went in that direction. With respect to monitoring temperature or other conditions in the brook, I think as some of the crowdsourcing mentioned, there are avenues for public groups, Green Acton, concerned citizens to do that. That collection can take place. But in terms of it being imposed on Concord as a part of this permit, we would not accept that. With respect to monitoring overflows of the dam, that is not something that we have any mechanism for measuring, and likewise, I think would butt up against the limits of the Water Management Act and the ability for this zoning decision to impose a control on that resource.
Okay, thank you. Peter, did you have any other questions or comments? You were launching into your explanation of your feeling about the decision, and you mentioned that particular issue, but I don't know if you had anything else to say about the decision as a whole and its current state with the proposed changes. Thank you, Peter.
Yeah, I mean, I recognize that people will be disappointed that I'm going to vote to approve this modified decision. Certainly have been a lot of emotion, understandably, generated by this whole process. The biggest concerns expressed have been the effects on Concord's increased withdrawals from Nagog Pond on the vitality of the pond itself and on Acton's long-term water supply. As we've learned, we don't have the legal authority to limit Acton's ability to withdraw at their approved rates from the pond. Zoning is not really an appropriate vehicle to resolve water disputes. It deals more with buildings and siting of buildings and size of buildings and other kinds of issues. I am still comfortable with the finding that this modified decision is consistent with Acton's master plan. Concord's been withdrawing water from Nagog Pond for over 100 years. They've protected 60 acres of open space, which otherwise could have been developed, and have been good stewards of the pond, consistent with their mission of providing potable water to the residents of Concord. The Acton Water District has indicated they're not anticipate any need to use Nagog Pond as a source in the future, but if they ever did, they don't own any land on the pond. They don't have a facility that could treat surface water to the level it needs to be treated. So their best option would be to work with Concord to be able to access water that Concord's able to treat through their plant. So I am comfortable that this modified decision is consistent with the master plan and meets the other findings that we're required to make with the conditions that we put in here. I agree with Katie. We had a group, citizens group called ACES, Active Citizens for Environmental Safety, led by Charlotte Sagerhoff and Mary Michelman for many years. Both unfortunately have passed on at this point, but they were extremely effective in holding Grace's and the EPA, U.S. Environmental Protection Agency's feet to the fire in cleaning up the Superfund site. And it would be great if all this energy and knowledge that has been generated about the water issues through this process, a citizens group could get together and get involved in Concord's reapplication for their registration and permit to draw water from Nagog Pond. There is a citizens comment period that's allowed in that process. I'm understanding it will come up next year before I would assume construction will start on this. So now's the time to get involved. Senator Eldridge encouraged people to get involved to help update the state statutes. If we need to clarify what Acton's rights are under the original 1884 Act, I would think a citizens group that would focus on those issues and try to move those issues forward would be entirely appropriate way to deal with it, given the limitations we have in this zoning process. So, thank you.
Joe?
I hope I can talk. I have bronchitis, so I'm new to the board and wasn't here during the public hearings, but the emails that have come in over the last few months have been extraordinary. I think I'm concerned about the impact on the neighborhood and the size of the building. I recognize that it's a zoning decision and not really a water issue, but I had the site plan for the W.R. Grace many years ago that created the beginning of it as a Superfund site. I have some concerns about the water issues in town. And I know that Concord has been very foresighted in dealing with Nagog Pond and the facility. But I think there are many unknowns about the impact of this facility. I drove up into the neighborhood to try and find the path. I didn't find it easy, and I'm concerned about the chemical truck deliveries in that neighborhood. So those are my issues.
Are you prepared at this point to say whether you support the proposed changes and the overall decision? Or are you inclined to make changes? And Kingston obviously would like to make changes. He's not prepared to support the decision in its current state with the proposed changes. But I don't know what, you have concerns. We all have concerns, but I don't know what that means insofar as your opinion of the current proposed draft decision is concerned. If you want to wait, I can make my comments and then we'll come back to you. Give it a little thought and rest your voice. A few weeks ago, Joan and I both were hacking away, and I barely had a voice, and poor Katie was in the middle, worried that whatever we had was very contagious, but Joan is still recovering. In any event, I will offer my comments. Essentially, I'm prepared to approve this proposed amended decision. I think that I really do appreciate the amount of engagement that this issue has brought in our town with regard to water issues. I think that one of the things that concerns me is that people who are, well, frankly, there's a lot of emotion and anger too at Concord. I think one of the things that people are perhaps not giving enough weight to, that I think Peter mentioned in his comments, is that Concord has aggregated a swath of 60 acres of land, almost all of which is undeveloped and open, and is wonderful habitat, and it's beautiful, and it's for a purpose. They aggregated it, but it is a very attractive place, and it is one of the reasons, I think, frankly, that living in that area is a little more pleasant. If that land, it is held by a public entity, as Katie said, but it does not mean that it's open to the public. It is not like our Nagog Hill conservation land or other conservation lands, which are held by a public entity and also open to the public. But I think that I think that, yeah, being denied access, once you've had access to something, it's very hard to have it curtailed or even shut off, and something good. But I think that if that property had been held by a private owner, it's possible it would have been developed, sold off and developed and extended one of the subdivisions that exists at present, or created a new subdivision. So I think that it's important to recognize that when we're talking about the master plan and even the purpose of the bylaws, one of the drives in the master plan is caring about our natural resources. It is not the only thing in the master plan, but if you look at just the big picture and which part of that area actually is most consistent with a master plan or with a bylaw whose aim is, among other things, to reduce density and traffic and all of that, I would say that that property, Concord's property, probably serves more of those interests than do, say, the surrounding areas. But that is really what I keep coming back to, is that this is just by virtue of need, turning out to be, perhaps more consistent with some of the values that people in this community hold dear. I also think that it's important for us to focus on what this decision is. It is a zoning bylaw decision. I don't want to belabor that. I do firmly believe that the Water Management Act makes clear that the authority is the state. It is not this board. I also happen to believe, and I said this at our meeting on the 20th, that there's a problem if registered water rights are not subject to any kind of conditions. I know that Senator Eldridge, when he spoke, said that a lot of the water districts were in league and opposed any kind of change in that. Well, I think that just means you have to try harder. I don't think that the water districts are some sort of terrible they're not terrible entities, they're not mean-spirited, they're not evil. They have a responsibility to provide water to a lot of people in our state, and I think that you need to consider their concerns when you're going to try to change the regulatory structure that affects them. So, but I think that is the level. We're not going to solve that issue with this decision. This board is not, this is not our authority. And I do echo what my colleagues have said about our intention, our good faith intention to move forward with a lot of the things that we said we would do, including in recommending the non-binding resolutions that were at town meeting earlier this year. I think that a lot of those actions make a lot of sense. Certainly the collaboration with other towns maybe area-wide or regionally, make a lot of sense. That's another reason that I support approving this decision, because I want to maintain good relations with our neighbor, with whom we have to work on other issues. This is hardly the only issue we're going to work with. For some people in the audience, it may be the only issue, but this is hardly the only issue we're going to be dealing with where we need to collaborate. I think that increasingly we're going to have to collaborate with neighboring towns because, frankly, I haven't noticed that population is dropping anywhere. It's growing. The planet is growing in population. I had an epiphany. There are more people, there are more cars, there's more everything. So, frankly, a collaboration and cooperation is going to be the name of the game, unless somebody's going to be starting a lot of wars and sort of reduce population that way. But I do think that we can make the mandatory findings that the zoning bylaw requires. About, as Peter said, consistency with the master plan, in harmony with the purpose and intent of the bylaw. If you look at the bylaw, its purpose covers a lot of issues, and not just, preservation of natural resources. And if you look at all the different issues that the bylaw is supposed to be addressing, I would say that allowing this water treatment plant to go forward actually on a 60-acre swath of land, would probably serve a lot of those purposes. And the detriment to the neighborhood, I understand that having chemical delivery trucks is a concern for people in the neighborhood. We have tried to alleviate that concern as much as possible without completely prohibiting vehicles. There are other vehicles in the neighborhood. There are buses, there are UPS trucks, which in my experience are incredibly recklessly driven. There are fuel delivery trucks. There are, any number of other vehicles that drive, including, perhaps some people who are talking on cell phones and distracted. So I think that we have tried to alleviate that concern as best we can, but honestly, the roads are there to be used, and I don't think that it's fair to prevent Concord from doing what it is required to do, because they can't get deliveries of the materials they need to do what they have to do. So anyhow, that is all I have to say. And I don't know, Ching Song, if Joan, you're ready to complete your.
I would like to speak before you ask Joan whether or not she's willing to support this decision. So I guess I wanted to elaborate on my position in terms of macro level comments related to both the original decision as well as this decision, how this operates in my view as a zoning decision, and sort of the concerns involved that have both been raised by the community as well as that this board has mulled over. With the original decision, given the position and sort of the amount of effort that I'd put into it, I entered the negotiations with, I entered the process of writing the decision not with the intent of trying to create the best possible zoning decision, but to sufficiently mitigate the concerns that I had so that it would be possible to allow the plant to move forward. I thought that was in the best interests of everybody involved, if that compromise could be reached. So the concerns I have in general, related both to this decision as well as the original decision, are primarily related to three things. The first is the use of the site as a water treatment facility at all. I think that in 1995 this was much more palatable than it is today, but I think overall, without specific affirmation and an enforcement mechanism of Section 10 of the 1884 Act, which gives Concord rights to this pond, but also clearly states that Acton's rights supersede those of Concord's. Without specific language, I do not think that that acknowledges that fact. I do not think that that it is possible for the special use permit to comply with the master plan's objective of protecting water resources in Acton. However, given that a permit was issued in 1995, that's also a condition that we have to consider. But now we talk about the specific siting of the plant in its current location. In 1995, Concord was proposing a much smaller facility in essentially what we might consider the middle of nowhere. It was in the woods. There really wasn't a whole lot around. And so in that sense, it was actually a decent location to build a treatment facility. Today, we are looking at a very different situation. We are looking at a large residential development that has now in the area. There is a golf course in the area, and Concord is proposing a much larger facility with a much larger effective footprint in many senses due to the security fencing that they have decided is necessary. While I don't contest Concord's assessment that the security fencing is necessary, it does increase the effective footprint of the facility and the effective reach of that on residents. It is very clear to me from that if this were a new application in this location, I would deny it simply on the basis of I do not think it's appropriate to build such a facility with such a large footprint so close to a residential neighborhood. The third factor is whether or not this facility is injurious or detrimental to the neighborhood in question. I do think that that question, this facility still, as designed, teeters on the borderline of that, and that if there were negative impacts beyond what is currently shown, it would definitely fall into injurious. And so allow me to elaborate on that. I do think many of the residents of Breezy Point and Quail Ridge and Acorn Park clearly utilize the land around Nagog Pond and the Nagog Hill Conservation Area as passive and active recreation. And for those purposes, the effective increased footprint of this facility due to the security fencing clearly is significantly detrimental to the quality of life of the residents in the neighborhood. This is before we get into the construction period, as well as the fact that there will now be chemical delivery trucks running up and down Hazelnut, which in an increased frequency, which presents an increased risk in and of itself. The area around Nagog Pond is a woodland and a wetland that is essentially very natural and very well preserved and has a lot of plant life and wildlife. And this includes the cold water fishery of Nagog Brook. I think if any of these things were to be noticeably damaged by Concord's operation of this facility and the increased water withdrawal that the facility represents, it would easily cross into injurious to the neighborhood, because one of the main appeals of living in this area, no doubt, is the natural surroundings and some of the beautiful land that you have access to, whether or not this access is by right or given by de facto due to Concord's lack of strict enforcement of its borders, of its land. So while I hear the board's comments that the fact that Concord owns 60 acres of land and has kept it relatively naturally preserved, they are under no obligation to do so, and while I think that they will continue to do so, the fact that there will be less water available could very well cause detrimental impacts to the foliage and to plant life, and to wildlife. Sorry, foliage is plant life. Those effects are unknown, and Concord cannot guarantee that Nagog Pond will continue to remain, especially with climate change being a concern. Concord cannot guarantee that Nagog Pond will continue to be the natural setting, the amazing natural setting that it is. And so I think that the loss of this natural setting would, of course, be injurious to this community, and this facility, I think, in general, presents an unacceptable risk that would occur. And so I think that while, as with the original decision, included sufficient conditions that I think made it so that the combined level of all of these concerns was lowered to the point where it was at least tolerable, if not mitigated to an extent that I would find reasonable. But, I would find fully acceptable, was at least tolerable. The decision here today that we are presented with is a much better decision from a zoning and legal standpoint. I will not contest that fact. However, it is also a decision which I believe now forces me to vote that it is inconsistent with the aspects of the master plan which were basically remain the same, but now no longer have as much language, strong language, or conditions associated with mitigating them. And so that is sort of how I feel about both decisions and why I asked you for 2 votes. Because I do feel that from a legal standpoint and from a zoning argument standpoint, this decision is better. But I also feel that the better decision doesn't necessarily mean that from a legal standpoint, doesn't mean it's a better decision from a town interest standpoint.
Okay, thank you. I'm so tempted to ask you a question, Ching-Sung, but I won't. Joan, are you not ready to talk, or? All right. Council, where do we go from here?
I'd suggest we start with a 10 or 15 minute break.
Okay, that's a good idea. And maybe, Joan, I have cough drops. Do they help? Oh, water. Yeah. We'll take a little bit of a break, and I need to confer with you. Thank you. The break went a little bit longer than, I think, 15 minutes, but if everybody would return to their seats, that would be great. All right, I think that where we left off, I was about to ask Joan if she was ready to say anything or not about what she thinks about the proposed amended decision.
Jen, I'm sorry, before you get to that, okay. Can I just explain sort of some of the what I was trying to sort out here so that everyone is understanding of that? So, you know, there were a couple awkward things about the process tonight that was giving me concern. So I wanted to, number one, discuss with Concord whether or not they would be receptive to an agreement to extend the deliberation period if there was a board member or more that wanted more time to digest information. And they've said that they'd be fine with that if the board members wanted it. I was kind of trying to get a handle on Ching-Sung's suggestion that there be 2 votes, and Ching-Sung, I don't know if you want to sort of, I just want to bring to the public sort of that my understanding of that conversation was that what I was trying to clarify, and I'll clarify it for everyone here, is that if there's what I was understanding from Ching-Sung is he views the modified decision as an improvement with respect to the zoning parameters as a zoning decision, but, correct me if I'm wrong, but as modified, because these decisions no longer provide the mitigation you would have been looking for previously, you would no longer view the project as complying with the special permit criteria.
That is correct.
Okay, so your vote, so my response to that is basically, it sounds like not 2 votes, it's really 1 vote. So that 2 vote thing I was trying to wrap my head around, and that I think we're sort of back to the notion that there's going to be one vote. Because the task here for the board, the question for the board is whether or not, as modified, you would issue these approvals with this modified language. Does the board as an entity still view the project as complying with the applicable criteria if conditioned as it is in the modified decision? If the board thinks as modified the project doesn't meet the criteria, then it's a no vote on the question of whether to adopt that modified decision. If there are not 4 affirmative votes on accepting the modified decision, just so everyone's clear as to what happens there. I'm not trying to influence anything by saying this, but I want everyone to understand where we go. That doesn't mean that the project is denied, okay? This is not a process where we are reconsidering in its entirety the original decision. The question here is whether or not the original decision should be altered, modified as proposed in this decision. So if the answer to that as a board is no, or we don't get 4 yeses, then what happens is we revert back. This modified decision becomes, it has no effectiveness in any way, shape, or form. It's out. We revert back to the original decision, which is the approval with the original conditions, and it goes back before the land court, okay? And at that point, we're defending the original decision. So I just want to make sure everyone is clear as to, you know, what the vote is and what the, you know, the outcomes are. So are there any more questions on that we should discuss? Okay, so now the other thing I was trying to get a handle on was, Joan, you had expressed some concerns that you had. They sounded like they were responding to comments that came in Monday, and prior to that through the written emails and other public comments that have been submitted. And I just wanted to, because you weren't involved with the first hearing process, all that information is incorporated into this record. My understanding was that you had reviewed those materials. I mean, can you just confirm that? So.
Yes, I have.
Okay. And so the question for you is whether or not you feel like you want more time to either further review the information that goes to the concerns that you have, or if you feel like you're prepared to vote this evening, whichever way you're inclined to vote.
I'm comfortable voting.
Okay. All right. So with all of that, Janet, I'll turn it back to you. And I don't know if you were going to ask, I'll just turn it back to you unless you have other questions on that.
Okay, just to go back to Ching Sung, just clarify, at this point I don't remember whether you said that as to the full decision with the proposed amendments, you would be a no vote.
At this point, I would not support the modification. Given what Jeff is saying, I would be forced to vote no because I do not feel that this decision allows the project to comply with the findings that we have to make.
Okay.
However, I did present you with the idea that there is a subset of these modifications that I am okay with. There's just enough of them that I'm not.
Yes, the mitigation provisions. Okay. Joan.
I'm prepared to vote no.
Okay, well, that means that we have 3 people on record as supporting the modified edition version and 2 potential no votes, which means we don't have the 4 votes to approve the decision as modified, which means what? We revert to the original decision.
Sorry.
Unless we can discuss potential modifications that would make the 2 no votes be able to support the decision as modified, but further modified. But then the question is whether the other 3 selectmen would be comfortable with that, and bearing in mind that this proposed modified decision is the result of settlement negotiations. The idea was that this was a decision that, if it were approved, would resolve the pending litigation. The issue would be, concern would be, would Concord be prepared to agree to the further modifications that Ching Sung and or Joan wanted, assuming that the other 3 members were also prepared to support them, which is a big if, so not having really at this point discussed them. So
I do think that it's worth having that conversation, as I outlined at the beginning, and, you know, you may end up with a modified decision, which at least narrows the issues that are going to be litigated, but obviously your understanding should be that, you know, unless Concord's prepared to respond to proposed revisions that the majority of you want to make a motion on, you know, I think the assumption is that there's a pretty good likelihood that whatever you come out with will end up back in land court, but maybe it's a narrower set of issues. So I do think it's worth exploring possibilities there.
Okay, well, I'll start with Ching Sung to give John a little break.
Okay. I am okay with all revisions prior to the removal. Actually, I am just okay with all revisions prior to the removal of the monitoring program. So all of those revisions I am willing to support. So everything on pages 1 through 16.
I'm sorry, Ching Sung, you're looking at the red line version?
Yes.
Okay.
So everything on pages 1 through 16 I am completely okay with. I am also okay with the removal of the monitoring program, although I would like some language put back in as far as protection of Nagog Brook in some way, shape, or form, whether or not whether I don't think that language, as Concord has stated, should obligate Concord to institute a I guess, monitoring program of their own, but perhaps, I don't know, there's a bunch of ideas that I had with respect to this. The one that I think is perhaps most valid is agreeing to some sort of expedited review process in the event that monitoring that Acton or citizens of Acton produce in Nagog Brook represents some kind of, shows real concern to the continued viability of the cold water fishery. So I very much am okay with narrowing the scope and changing
review process by whom?
By Concord specifically, as well as escalation to a state level if necessary. And then so there's that. And then I guess I am okay rewriting to some extent the language in old 339 and 339, 10, and 11, and 12, so that section, water supply coordination and planning. I do think that it is possible for that section to be better written than original, but I'm not okay with the substantive changes that have occurred in that section. So as far as wordsmithing and some other stuff like that, I think that it is possible to make changes that are, I suppose, tighter, that write that section tighter. I don't have prepared changes because I wasn't anticipating the need to discuss that tonight, although it is something that I could at least work on. And then 3310, the construction modifications, I'm essentially okay with. There's really nothing there. 341, the modifications there, I'm also largely okay with.
Sorry, did you respond to the coordination regarding trails is 339?
Yeah, sorry. What I meant was the old water supply and coordination planning, that entire section. There were many substantive changes in that section. I'm generally not okay with that. Wordsmithing that to make it tighter and more accurately reflect what the board's intentions are and sort of what the purpose of these conditions are, I'm okay with that. I do think that perhaps this section maybe could have been a little bit better written on second look. And so I don't know whether or not we want to entertain some additional time to go through that process or just go forward with the original language.
So let me clarify, you just said, I think you said you want to retain the water supply coordination and planning and the coordination regarding trails, but you want to change the language. Make it tighter.
I don't need to change the language. I'm okay with the language as is, but I do think that there is potential to improve the decision by improving the language. So the question is whether or not we want to spend the time to do that, or whether or not we just want to go forward with the original.
Well, is changing the language going to make a difference if, assuming that, you know, people are okay with the other proposed changes, or is this sort of, you don't really care that much about it? I just, you know, if you're bringing it up, I assume that it's of concern to you, so.
It's not of concern to me in the sense that it would, that I think that it would substantively change anything. But I do think that just from a writing standpoint that it could be clearer, and that is something that's always good to strive for. Like I said, it's a nice to have, not necessary. I would be perfectly okay retaining the original language. I do think that some clarification may help future people when reading this, who don't want to go through and watch all of our deliberations and understand everything that's happened. And so I think that to that end, you know, it might be useful, but it's not.
So for both, I'm just trying, water supply coordination and trail
yes.
issues, you think you would just like the language to be clearer.
Yes.
You're okay with the substance, but you just want to do some wordsmithing.
Just to clarify, he's okay with the original substance.
I'm okay with the original substance,
okay.
Yes.
Okay.
Yes. The original language, I'm okay with it substantively. I think it could be cleared up and written slightly better. Yeah. But that's not a real pressing concern. It's also the modifications may not affect any sort of legal considerations at all. In fact, I think it's reasonably likely that they don't, because the only thing that I would say that I think could be helped is really to help understand the intention and sort of the purpose behind these kinds of conditions, and sort of what they are looking to implement, and not sort of, you know, anyway. Basically that.
All right, understood.
Sorry, can I just ask one clarifying question on that one? Because within that section, we have the 2A service. Do you have a view on whether you would impose that requirement that they continue to provide water on 2A as part of the special permit decision?
I think that the easiest thing to do would simply be to require the signing of an intermunicipal agreement within a period of time, and the intermunicipal agreement would include 2A. That is, I think, the cleanest way of doing it. However, should we want to break out the parts, I do think it is necessary for the 2A issue to be resolved one way or the other.
Yeah, I just want to say, I think that at this point, we're getting into changes that we know based on discussions that we've had during discussions with Concord that they will not agree to. And so at this point, I don't think it's actually a really fruitful use of this board's time or the public's time to go through and try to change this. And frankly, I'm feeling at this point that we should just vote on this modified decision, understanding that it's going to be voted down, and that we revert to the original decision and we go back to litigation. And litigation, if Concord wants to engage in a new round of, you know, discussions with us, we can do that, and we can see if there are a more narrow set of changes. But frankly, that was the point of these discussions leading up to this. So it's not as though that work hasn't happened. So I just think that at this point, it makes more sense to recognize that, to vote no on, or to take a vote that is ultimately not going to succeed in passing the modified decision, and go back to litigation. That's where we are.
I agree with that.
Yeah, so I just think...
Can I just ask, though, I don't know, Joan, I know you're having a hard time talking tonight, which makes it even more difficult, but are there particular modifications in here that, are there revisions that are not so significant as those that Ching Sung is proposing that might sort of get you to the point where you would find compliance based upon the modified decision. And I know it's difficult, but I do think it's probably worth understanding better sort of what parts of the modified decision you think bring this decision from a point where it was determined to have complied to a point where it no longer complies.
.23, 10.351, consistent with the master plan. 10.353, injurious to the neighborhood. It's 2.25, 10.452, adverse effects on the natural environment. The monitoring program, 337. And 338. That's 2A.
So the answer is no. I mean, there are not changes that we can make tonight or that we would make that would get a supermajority of this board to agree to this. That would be things that we know Concord is comfortable with. So with that understood, I think the process is first we close the hearing and then take a vote on it.
Yeah, I think that's right. Let's motion to close the hearing, and then a motion, the motion would be in the form of a motion for approval.
For approval, yeah.
Right.
So I'm going to move to close the hearing.
I would just add that I agree with Katie and Peter. It's pretty clear that, there's a real division of opinion, and there's no way that we're going to get agreement, first of all, of this full board plus the town of Concord to any of these proposed changes. We've already been through that, so.
I'll second the motion to
okay,
close.
Katie moves, Peter seconds to close the hearing. Any further discussion? All those in favor say aye. Aye. Opposed, abstaining.
Okay, so I will move to approve the modified decision.
Second.
Katie moves, Peter seconds to approve the modified decision. Any further discussion? All those in favor say aye. Aye. Opposed?
Nay.
Abstaining. So we have a 3-2 vote. It's not a supermajority, and we're done.
So I will make a motion to adjourn.
Second.
Katie moves, Peter seconds. Any further discussion? I hope not. All those in favor say aye.
Aye.
Aye. Opposed? Abstaining.